Okay, good afternoon.
Good afternoon, Your Honor.
We're here on the case of School Board of Volusia County versus Florida East Coast Charter School. The other members of the panel joining me today are Judge Meredith Sasso, and we also have sitting as Associate Judge from the 11th Circuit, Judge Ramiro Recess. So we're glad he could be here to help us on this case. You all have a clock on the screen?
Yes, sir.
Okay, so if Appellant's counsel wants to let me know how much time they wish to reserve for rebuttal, I'll try to help you in that regard, but you do have the clock there to watch as well.
I would reserve half, Your Honor, 10 minutes.
Okay. And Ms. June, I think it will need your volume to go up a little. Also, this oral argument is being live streamed on YouTube and also being recorded so the members of the public can view it. And with that, Appellant's counsel may proceed.
Your Honor, may it please the court, is my volume okay now?
Little higher.
Let's see. Okay. Let's see.
Okay, that's good.
Your Honors, may it please the court. My name is Carol Yoon. I represent the appellant, the School Board of Volusia County. First off, I wanted to bring to the court's attention, I did file a notice of supplemental authority this morning, bringing to the court's attention Florida Administrative Code 6A-6.0781. So I did want to bring that to the court's attention first.
Thank you.
Our appeal today involves, at its core, the State Board of Education's attempts to undermine the authority and power constitutionally and statutorily given solely to the school board. Under Florida statutes 1002.33, the school board, a body of constitutionally elected officers, is the sole designated entity tasked to vet charter school applicants. And if this charter school is approved, the school board then has the authority to oversee the charter school. The state, and back in 2018, unsuccessfully tried to propose an amendment 8 to the Constitution, which was aimed at overturning a 2008 appellate court decision that found that the legislator's creation of a statewide commission to authorize charter schools was unconstitutional. That proposal was unsuccessful. However, it solidifies the fact that the state is not ignorant of the.
You hold on 1 second. I think we lost Judge Sasso for a minute. Marshall, stop the clock here. The Zoom oral arguments have worked pretty well for us, but obviously not with perfection.
If it looks like she may be in by phone, I've cleared her to talk by phone.
Okay, Judge Sasso, can you hear us?
Can you hear me now?
Yes.
Okay, sorry, that's the first time this has happened in all this time.
Okay.
We can continue with me on the phone though, if that's okay.
Yes, we'll go ahead and continue. Okay, Ms. Ewan, sorry for the interruption.
No problem. I don't know when she cut off, so I'll just try to start. Back in 2018, the state unsuccessfully proposed an Amendment 8 to the Constitution, which was aimed at overturning a 2008 appellate court decision that found that the legislator's creation of a statewide commission to authorize charter schools was unconstitutional. That proposal, Amendment 8, was unsuccessful. However, it further solidifies that the state is not ignorant of this exclusive authority that the statute and the Constitution provides to the school board as the sole entity to authorize charter schools. Taking seriously its task to provide provided under the Florida statutes, the school district spends countless hours of staff time and resources to review each charter school application to determine whether a charter school applicant has met all the legal standards to show that it has the capacity to operate a successful charter school.
Let me ask you this.
Yes.
Been struggling a little with the standard of review here. And of course, it seems that the state board needs to review the county board's decision to look for competent, substantial evidence that there was good cause to deny the application. Would that be a fair statement?
Yes, Your Honor. That's a fair statement.
Okay. If, for instance, the county board found 2 deficiencies in the application, and they deemed those deficiencies to be sufficient to establish good cause to deny the application. And I know this is a hypothetical, not exactly the facts here. But if the state board had no disagreement on the facts, but determined that those 2 deficiencies did not constitute good cause, how do we assess that situation?
I think there's 2 aspects to what Your Honor is proposing. First of all, there has to be deference given to the fact finder, which is the school board. And their fact finding is, I guess, essentially what a trial court, similarly or comparably to what a trial court does, which is they are presented all this evidence that they are able to weigh the evidence and make a decision. At the appeals commission level, which is more of an appellate level, they have to assess based on the standard, which is competent substantial evidence standard. And that is based on the record. They are not able to reweigh any evidence. They are not able to bring in new evidence. There is no testimony and no evidence.
Right, but let's assume there's no factual deference to be given because there's no facts in dispute. You have an application that says under, paragraph 7A, here's our plan, and the county board says that's not a sufficient basis, that's not adequate. So we find a sufficient basis to find good cause to deny your application. And the state board takes the exact same provision in the plan and says, no, there's no good cause to deny the application. So let's leave out the factual deference part that you mentioned.
Yes, if there's no dispute to the facts and it just goes to the appeal commission and they're just looking at the facts as undisputed, what they would do is they're able to do is a de novo review of the good cause standard. And that is looking at the facts and to determine legally whether that was legally sufficient reason. And that's based on preponderance of the evidence standard as well, I would like to point out. So it's not but in this case, we don't have undisputed facts. We have conflicting evidence. There was a lot of evidence produced at the school board, and at the appeals commission level, there was new evidence presented, which is not allowed under the standard of review, is not allowed under the Florida Administrative Code that I mentioned earlier today. And
the new evidence, are you referring primarily to the bit about the guarantors?
Yes, Your Honor.
But that's not in the commission's order, is it?
It was in the commission's recommendation. If you look at the recommendation by the appeals commission, which
okay, I mean, we don't know. It's not in the school boards. Well, I guess they adopted the recommendation. Okay. All right, go ahead.
So can I ask you a question? Sorry, this is Meredith Sassa. Your interpretation that the commission is essentially confined to a record on appeal.
Yes,
is that based on your interpretation of the statutory provision or as laid out in the regulation?
As laid out in the regulation, as well as the case law that I cited to you regarding the competent substantial evidence rule, as well as the interpretation of statute, because you can't have an interpretation of statute that will lead to an absurd result, which I raised in my initial brief. And in this case, you cannot say that the school board lacked competent substantial evidence based on evidence that was never before the school board. And that just wouldn't make sense.
Well, you cited absurd result, but let's also, we are also supposed to interpret the statute as a whole. And so when the statute specifically contemplates that the school board, that the state board and the commission can receive additional information relevant to the appeal. How do we give effect to that language based on your interpretation of the reviewing bodies being confined to a technical record on appeal?
Yes, Your Honor. As I was stating in my initial brief, that particular statute section that Your Honor is referencing is talking about asking for clarifying information. And that would need to be tailored to the fact that on appeal, they have an appellate record, which the Appeals Commission is subject to only the appellate record. And that's shown also in the 6A-6.078, which says that there should be no evidence or testimony presented at the Appeals Commission level. What really comes down to the clarifying, the particular word clarifying, is that it should be that whatever is applicable to the appellate record, what's in the appellate record. They cannot go beyond that. And this is what happened in our case, which is they tried to go beyond what's in the appellate record. Clarifying.
Okay, and so when we look at that in conjunction with the regulations that are also passed, record on appeal is referenced in the regulations, but then the regulations go on to say that in subsection A, that there will be a hearing before the Charter School Appeal Commission. Each party will be given a maximum of 10 minutes. And then it says at that time, only oral argument, no evidence will be received or testimony presented, which suggests that in subsection B, when it refers to a different procedure, and this is where the Charter Commission is allowed to, the Appeal Commission is permitted to request information to clarify the documentation. That doesn't have that same limitation. So how does your interpretation of what the commission is allowed to consider give effect to those provisions in the regulations?
The interpretation would be that the clarifying the documentation is clarifying the documentation already in the record. For example, if we were to appeal to the appellate court level in a court setting, the appellate court still subject to only what's in the appellate record. Now, there could be maybe questions of a particular, what is this document, for example? Maybe they didn't understand a document, but not bringing in new content or new substantive material based on new testimony, new evidence, is what I'm saying. That
did the parties here submit new documentation, or were they just providing additional information in response to the questions they received?
I would state that the evidence that they stated, it's not new documentation, but they provided new evidence. For example, the guarantor, the fact that the landlord is a guarantor, that was never produced or provided at any stage of the application stage or the capacity interview, or even before the school board. While there was an imposition of a question to the appellee at the Appeals Commission, the school board immediately objected to the response that the appellee gave, which was because it was new evidence, that was not something that was considered by properly before the school board. So what I would say that, I guess, is that the clarifying information based on the documentation should be narrowly tailored. Otherwise, what is the point of a school board having a statutory authority under 1002.33 to vet these charter applications, and then an appeal, the applicant can bring in new evidence and essentially submit a new application in front of the Appeals Commission. And what I'm saying is that,
I mean, I think the point, when especially this is not a judicial branch proceeding, it appears that the legislature has created a system that's more merit-based rather than more, technicality-based. On the judicial branch, we value finality of judgment, and in the scheme of approving charter school applications, it doesn't appear that same emphasis is driving these regulations. So I guess my concern, what I'm having a hard time with is reading in kind of temporal and categorical limitations into the statutory language of what is meant by, information meant to clarify the appeal, when those requirements are just not laid out in the statute.
I understand.
I guess what do we look to read in those limitations?
What I would say is what I presented before, which is that the sole entity who is designated to be the body are the constitutional officers elected, the school board, who is able to vet these charter applications. Now, if you are stating that by the legislators' term, clarify the documents or additional applicable evidence, that they can bring in new evidence at the appeals level, you're basically undermining or even usurping the authority that the statute and the Constitution provides the school board, this authority, the exclusive authority.
Ms. Yoon, if I may, just for a moment, along the lines of what Judge Sasso is asking is, where, if anywhere, do we draw the line? So, for example, the statute 1002.336E2 refers to appeal documents. And then if you look at the rule that you've provided by way of supplemental authority, it seems to suggest that they use appeal documents to include the record on appeal in addition to all written oral arguments and exhibits. So if that is what the appeal documents are, then what are they referring to when they say that we can gather when the commission can gather other applicable information in addition to the appeal documents? It would seem that they are referring to a class of documents or a class of information that is separate and apart from what would make up the appeal document, which includes, as you say, the record.
Yes, so I would say that when you read this, it says request information to clarify documentation presented to the charter school. And it says as set forth in the appeal and exhibit thereto. So that language right there limits it to the appellate record. So what I would argue with that is that the clarifying information still needs to be limited to what is in the appellate record.
Where are you reading that from?
The 6A-6.0781.
Oh, okay, I'm referring to the statute 1002.336E2, which says that the commission may receive copies of the appeal documents, review the documents, gather other applicable information regarding the appeal. And so if the appeal documents already includes the record, the written arguments, the exhibits, and all transcripts of all proceedings below, what is left? What would be the other applicable information, if not the questions and answers that are alluded to both in the rule and in the statute by way of seeking clarifying information?
Oh, I would argue that it's the same thing as if I were to appeal to the 50CA case and my record was not complete. They can ask additional, make additional requests for additional documents that are in the record, which I may not have brought to the court's attention. And that would be the same thing in this case, which is that if there were any documents, for example, maybe a capacity interview was not part of the record, the appeals commission can then ask for additional documents that are applicable to the appeal, which would be a capacity interview, for example, but not anything that was never before the school board, which is not made a part of the appellate record.
Okay, I'm not following up because I believe she reserved some time, right?
You wish to reserve the remainder of time for rebuttal?
Yes, I do.
All right, thank you. For appellee.
Thank you, Your Honor. May it please the court, judges, counsel. My name is Sean Arnold and I represent FEC Charter School. Before this court this afternoon to say that the court should affirm the decision of the State Board of Education because there was competent substantial evidence in the State Board of Education's order to support its finding that the school board did not have competent substantial evidence to establish good cause for denying FEC's charter application. The school board's reasons for denial in this instance were based upon incorrect applications of the law, mathematical errors, and conclusions that were speculation and conjecture. This commission below did not rely on any improper evidence, did not rely on anything that wasn't subject to the charter statute or the two rules of administrative code, which we had already cited in our appeal. And I saw that appellant filed additional authority. This authority is already in the record and was cited in our brief. But the commission below was entitled to consider the statements made by the FEC team, not only at the capacity interview and the quasi-judicial hearing, but before the commission and before the argument before the state board.
Let me ask you this. If during the hearing before the commission, the school board attorney got up and said, on further review of the application, we have found additional reasons for denial, and then list those reasons, would that be permissible?
No, it wouldn't, Your Honor, because the rule and the statute says that there's a letter that's sent within 10 days of the school board's hearing, quasi-judicial hearing, stating the reasons why the denial is. And so in essence—
How about if it's additional information further supporting the reasons given in the denial?
I don't believe that the statute says that, and it's their burden.
Well, if you're interpreting additional information, I don't see in that section where it limits additional information as being from the applicant. So if the school board denied it for a particular reason and then said, and we have additional information as further support of that reason. And the reason I'm asking, I know it didn't happen in this case, but if we're going to look at how that statute should be interpreted, does it only, are you suggesting it only cuts one way, or does it cut both ways, or how do we view that?
I believe, so I think what's essential, Your Honor, in this instance is that there are questions that were asked of, clarifying questions that were asked of both the school board and the charter school at two levels. It's asked at the appeal commission, and then it's also asked at the State Board of Education. And I think it's important to point out that in the ruling by the State Board of Education, it says that everything was considered the school board's answers to the questions, as well as the appellate, as well as the.
Right. But you agree there's a difference between clarification and new information?
I think there absolutely is. And so, Your Honor, in this instance, this comes down to one thing, which is on the document that was the bank loan guarantee, it says guarantors to be determined. And the question by Mr. Moreno, who's the CPA who serves on that commission, said, what does this mean? And who are these people? And they said, well, it would include both the school and the landlord. And I think it's also very important to point out that the ruling by the commission says that it's considering everything that's in the application, which includes the $21.5 million of revenue that the school is going to receive, the $1.2 million budget surplus, as well as the $500,000 in contingency. That's what the loan was given for. The idea that the collateral, which is for a $40,000 loan on a $21.5 million budget, that what the amount of the collateral was in year one versus year 3 or 4, which I would again point to the record, say that the math by the school district is off by about $15,000 over the 5-year period. It's not competent substantial evidence to say that there's good that it meets the standard for good cause, and it's not new evidence. And a large amount of the brief was spent on this one issue, trying to basically relitigate, in my opinion, the Volusia case, which came out 12 years ago against the school district in a very similar situation. I don't think that there's any competent substantial evidence in this. And moreover, what's missing, Your Honor, from the record here is that is any evidence to support the school board's conclusion that the bank wouldn't give this loan. We presume this is a sophisticated banking industry, that the school board substituted judgment and said, well, they wouldn't possibly give that loan. And it's not based on any evidence. And even if they presented expert testimony, there would still have to be something. What's missing is I'm sorry, Your Honor.
In terms of what was the information that was provided to the appeal commission regarding the loan guarantee, was that, beyond clarifying, was that contrary to any evidence that was submitted to the school board, in your estimation?
I don't believe it was, Your Honor. And again, I think that this is a question that honestly, in doing the due diligence and having all the staff and hundreds of hours looking at this, is a question that should have been asked at the capacity interview or the quasi-judicial hearing. If this was a concern of theirs, they should have asked this. And as we pointed out in the brief, we have concern about the picking and choosing of answers that were given down below of what things were cited as being good cause or whatever. But I think that this is something that if they had a concern about, a sponsor who wants to do their due diligence on this would ask this question. So I think that based on what and I think that it's I think that the bank would have looked at the same application that was submitted to the sponsor in this instance, the Volusia County School Board, and look at this. And you have to look to see whether there's competent substantial evidence and whether that evidence amounts to good cause. Again, we'd say that there's no new evidence that's presented. It's not even cited in the State Board of Education's ruling that it relied upon this question. But the appellants in this case have latched onto this and devoted a lot of its brief to this one issue of a question asked by Mr. Moreno that doesn't even appear in the State Board's order. So I think that based on that in and of itself, I don't think that there's competent substantial. I think that the State Board of Education's ruling that the school district didn't have competent substantial evidence here was sound. And I think that applies to the other issues in this instance as well. When you look at the education plan, when you look at the other things in terms of the reasons that were stated, again, a lot of it is stating a law that doesn't apply, misinterpretations of the law, misinterpretations of the statute. When you're looking at such as the curriculum, it stated that the curriculum wasn't fully developed. The rule and the model application, and when I say the rule, it's adopted by a rule, and that's cited in the appeal, does not say that the curriculum needs to be fully developed. Despite that fact, the school district said that it wasn't fully developed. It also says that it gives the erroneous interpretation that K-5 instruction in PE must be given by a certified teacher, and that's not what the statute says. In looking at all the other things, including facility, food service, again, there's no competent substantial evidence to get this. Normally, when you're in front of the appeals commission, it's a two-part process. And if you read if you've read the record, you'll see it, that there is the question first is there any competent substantial evidence? And if there's no competent substantial evidence, you don't even get to the question of good cause. In this instance, the 4 members of the panel, 2 of whom are charter authorizers who work for school districts, I believe in this case it was Hillsborough and Miami-Dade, are on the commission. And then there's 2 representatives who represents charter schools. And in this instance, the vote was 4-0. In both instances that there was no competent substantial evidence, let alone to even get to the issue of good cause.
What is your response to that, to the argument that essentially that interpreting the statute in a way that allows the commission to consider additional facts or argument, or however you characterize it, beyond what was presented to the school board, cuts against the school board's constitutional authority?
So I would first of all, the issue about whether it was put up, I don't agree with the characterization as to why the 2018 didn't even make it to the ballot. That was a decision by the Florida Supreme Court that talked about the ballot language. But in terms of the authority, this is an additional level of review that the legislature has given in, which has, again, a panel of sophisticated people who work in this industry to ask clarifying questions and receive additional information that they believe is necessary. It's another level of review to make sure that the process is fair and that it's done in a way in which the State Board of Education, there are several cases, including UCP versus Osceola County, as well as the Volusia County case versus Academies of Excellence, both of which I've cited in here, which talk about the constitutionality of this process. So it almost sounds like an end run around those cases and making an argument that the Constitution is somehow offended by this process. This process has been reviewed by at least 2 courts in 2 different districts, and I believe that it's been brought up in the 4th DCA and some other ones. But I don't think it's beyond I don't think it's in controversy here that this process has been reviewed and that it's constitutional, is that it's another level of review and that it's done because the State Board of Education has supervisory authority over the education of children in the state of Florida. And there are certain home rule things that are done in Article 9, I believe it's sections 2 and 5 of the Florida Constitution. It talks about there's certain authorities that are vested in the local school districts. But there's case after case after case that discusses, and most recently affirmed by the Florida Supreme Court in the House Bill 7069 litigation, that discusses the fact that the Florida Department of Education has supervisory authority over the school districts. And that in this instance, if a charter school is denied, it has the right to appeal to a commission, which rejects the overwhelming majority of appeals that come before it. But in this instance, it granted it. And it has the ability to look at these appeals and see whether, and review it before and take it to the State Board of Education. So there are actually two intermediate levels of review before we ever got before this court this afternoon.
Let's assume that, it's a fine line between additional information and additional evidence. Let's assume that, we were to conclude that no new evidence was permitted. Tell us why you still win.
I don't think that there was no new evidence presented. And if I'm understanding your Honor.
Well, is there anything in the application about a guarantee from the landlord?
I would say that it says the guarantors to be determined.
Okay.
So in other words, that the bank has looked at the universe of guarantors that could be out there, said we'll determine that in the future, but in the interim, we've given a commitment to the fact that we'll give you this loan.
It doesn't even have to be the landlord. It could be various organizers of the school who agree to guarantee.
It could be a benefactor of the school, or Your Honor, I would contend that, not only in this realm, but in doing bond financing, a lot of that our firm does, they look at the revenues of the school. Again, they're projected to receive $21.5 million over 5 years with a nearly $2 million budget surplus when you add contingencies and surpluses. That's likely what they're looking at. And the idea
is failure to name the guarantors good cause to deny the application?
Absolutely not, Your Honor. I don't think it is. And so even if you wanted to say that the State Board of Education erred in determining that there was no competent substantial evidence, that you want to somehow rely upon the statement of the CFO of Volusia County in this instance, I don't think it rises to the level of good cause when you look at that. Even if that was true, that somehow they're, and I get the other point, Your Honor, is this, is that this idea about collateral, that somehow it had to be 100% of the loan value of the amount of the loan, there's no evidence of that. And that's another issue, that there's no competent substantial evidence to support what the school board did. They could have done that. They could have contacted the bank. They could have brought them to a hearing. They could have done any of those things and went to obtain that evidence, and they didn't do it. And I think the reason why they didn't do it was because they know what the answer would have been. And again, that's speculation on my part. But I think that the point is that you have to look at, again, when we're going to look at the record and we're going to take this idea of looking what's there, there's no competent substantial evidence to back that up. Again, what's in the record, and it's in pages 323 to 325 of the record before this court, is the budget that's proposed that says in the first 3 years they're going to pay the interest, and in year 4 they're going to pay the entire loan back. That is evidence. Speculation that somehow the loan to value of the collateral, which is only a very small part of what would be before this. I would argue it would be very similar to, any of us who, buy a house and get a mortgage. If the value of the house doesn't support the mortgage, they can come sue you personally. And I think that the name of the loan would have been the school. And I think just as one additional matter, they said, yeah, the landlord would be willing to guarantee it too. I don't think this court even has to accept that testimony. And I think that it's important that the State Board of Education didn't even include it in its order. Yet we've spent a lot of time on appeal talking about it. So if there aren't any other questions, Your Honor, to conclude, I would simply state that the school board presented insufficient evidence, and the State Board of Education correctly concluded that there was not competent substantial evidence to support the school board's denial in this instance. Thank you.
Are there any other questions from the panel? Okay.
Thank you.
Appellant, let me ask you, if the application said guarantors to be determined, is that good cause if they don't specify who it is to deny the application? And was it made given as a reason for the denial that the guarantors were not named?
I'm sorry, Your Honor, were you asking me? I didn't
Yes.
hear.
Yes.
Okay. Yes, I want to point to your honors to the statute 1002.336B, which clearly states what the application process is. It is the charter school that needs to have the proper, submit a proper application to the school board. What the school does is reviews that and makes a decision either to approve or deny it. Now they base our decision on the application as written. So if the application that was provided to us says to be determined, that says nothing really, because
But what aspect? There's also an instruction that the application should be, you know, based on the model application, and there's information to suggest that, you know, failure to meet a statutory requirement or something within the model application might be good cause for denial. But where is this issue with guarantor to be determined? Is that tied to any best practices or an aspect of the model application or any statutory requirement?
the statutory, I'm sorry, I thought you were.
Sorry, go ahead.
What I was stating is that the application as submitted, we review all of that. And that's what the basis of the decision of the school board is the written application. So if they submitted a commitment letter saying that their setup loan is going to be $40,000 based on collateral, and it says in the letter specifically that it's based on the collateral is the furniture, fixture, and equipment. There needs to be perfected lien on those things. And this is why there was an issue with it from the school board's perspective, because
what I'm trying to understand though is the school board's issue with that based on its conception of what a healthy loan is based on, or is it based on a violation of, you know, failing to comply with a model application or a statutory provision?
Well, the statutory provision provides that you have to show you're financially feasible, and that financial feasibility based on the application was the startup loan of $40,000, a commitment letter from a bank, and that was based on the collateral. So as the school board rightfully asked, is what is this collateral, this furniture, fixtures, and equipment? And there was conflicting evidence as to those things. Now, it's not the school board's statutory job or duty to go and call banks and see if that they actually committed to that loan. What they are basing their decisions, and rightfully so, is based on the application as written. And in this case, the commitment letter did not state a guarantor. And, you know, the school, the appellee had multiple opportunities to present that there's a guarantor if there was one. And in this case, I guess they're saying it's a landlord. But they had capacity interview, they had the application itself, but they also had a hearing before the school board where they can present that evidence, and they never did until they were in front of the appeals commission. My position on that is that the appeals commission is the second level of review, but the school board never even got a chance to review the new evidence that there's a guarantor. So how can you say that the appeals commission?
I apologize. Let me first refer to something that you just mentioned concerning a contradiction in the record, or that there were some inconsistent statements concerning the furniture or fixtures. You cite to an earlier portion, I believe it was at the capacity interview, where they're asked about what sort of furniture they need. And in response, they say, well, there's already furniture over there, so we need to walk through to determine what we need. And then those statements are then subsequently used to say that they contradicted themselves in the future when they refer to the equipment and furniture that's going to serve as collateral. But they never said that they were going to attempt to put the landlord's property up as collateral for the loan. That's not in the record. Additionally, at the capacity interview, it says there's a portion of the transcript, I believe it's at 364, where they are being told that this capacity interview is so that they can ask clarifying questions to things that need to be answered more carefully. So if there's an issue concerning who the guarantor is, and that concerns the school board with respect to their finances, why wouldn't that be a question that would need to be answered more fully? And is the school board's failure to ask that question somehow bar the commission from asking a clarifying question as to that same point? In other words, if you don't feel that they've provided significant or full answers concerning how the loan is going to be guaranteed, can you somehow prevent the commission from asking those questions by avoiding the question yourself?
Well, I guess what I'm confused at is there's two levels of what we're talking about here. The school board, in the review of that application, has the discretion to ask questions and clarifying information. That's separate from what the appeals commission has the authority to do. And in this case, the appeals commission cannot, elicit new evidence from a party is what I'm saying. So it's narrowly construed in terms of what their authority is on appeal. And I would say that in this particular case, especially when an applicant provides an application with a letter from a commitment letter from a bank, of course, if they have the opportunity, we've given them multiple opportunities to present thoroughly that they're going to be able to get this loan. And that was an issue raised multiple times with the appellee, and their failure to properly answer and show that they have the capacity to get this loan was the problem.
All right,
So-
go ahead. Just time has expired, but if you want to wrap up in 2 sentences or so, go ahead.
I would just ask that the court consider that if this court denies or affirms the school board's decision to deny the appellee's application, the appellee has the opportunity to come back in February to apply. They have further relief. But if this court does not uphold the school board's decision, not only would the school board's constitutional and statutory authority be undermined in the future, but there'll be detrimental and long-lasting harm to the students of the charter school not able to fully successfully open a charter school and to run it as it should, a highly successful charter school. So I'd ask the court.
Go ahead.
I would just
You're
say
asking
that
the
I would
court
ask
to
the court to uphold the school board's decision.
All right, thank you. Thank you both for your argument. Court will be recessed till 2:30.
Thank you.
Thank you.
Thank you, Your Honor.
Thanks, everyone.